Now I am going to dictate a latest Supreme Court judgment passage for upcoming Jharkhand High Court examination or any other court's examination at the rate of 120 words per minute. Let's start. The appellant was convicted for the offences punishable under Section 7 and Section 13 within bracket 2. Read with Section 13 within bracket 1 within bracket small d of the Prevention of Corruption Act 1988 within bracket for short the PC Act. The appellant was sentenced to undergo imprisonment for 1 year and to pay a fine of rupees 2000. High Court by the impugned judgment has confirmed the conviction and sentence of the appellant. The appellant was holding the post of sub-registrar at Kanaivadi, Dindugal district, Tamil Nadu. The complainant M. Sundar Murthy within bracket PW2 had purchased land measuring 16.05 cents accordingly on 12th July 2004. Sale deed was presented before the appellant, who was the sub-registrar in the concerned office. The complainant and his vendors were present according to the case made out by the complainant in his complaint. Apart from getting the sale deed typed on a stamp paper of rupees 880, he paid a sum of rupees 190 towards the registration charges of the sale deed. A receipt for the said amount was issued by the appellant on 16th July 2004. When the complainant visited the appellant's office, he was informed to bring FMB sketch from the concerned government office according to the complainant on 31st July 2004. The said sketch was produced by him. After the sketch was produced, the appellant informed him that he would have to make a site visit. Accordingly, the complainant arranged for transport for the appellant to enable him to make a site visit. After noticing trees on the land, the appellant instructed the complainant to get a TOPO sketch from the concerned office to show that the land subject matter of sale was cultivable. Thereafter, the complainant obtained requisite documents and handed over the same to the appellant on 6th August 2004 at 11:30 a.m. According to the complainant, at that time the appellant demanded gratification of rupees 500 for handing over the registered sale deed. As the complainant was not willing to give gratification on 11th August 2004, he filed a complaint with the Inspector of Police of the Anti-Corruption Unit. Based on the complaint, a trap was laid on 12th August 2004, which was unsuccessful. According to the prosecution case, the trap was again laid on 13th August 2004. It was successful, and in the presence of the shadow witness Michael within bracket PW3, the appellant was caught red-handed while accepting the bribe. The prosecution examined 12 witnesses. PW1 N. Dhaman Jian was examined to prove the sanction order as stated earlier. PW2 M. Sundarmurthy is the complainant and PW3 Michael is the shadow witness. No other witness is relevant for proving the alleged demand made by the appellant. The complainant within bracket PW2 did not support the prosecution and was declared as hostile. The appellant examined two defense witnesses, S. Dictation and Kolai Selvi, to bring on the record audit report of the offence in which the appellant was working and a circular issued by the Inspector General of Registration, which required the sub-registrar to visit a land subject matter of sale deed for ascertaining its valuation. The learned senior counsel Mr. S. Nagamuthu, appearing for the appellant, submitted that there was no charge framed as regards the demands made on 6th August 2004 and 13th August 2004, inviting our attention to the first charge framed by the special court. He urged that the charge is about the alleged demand made on 12th July 2004 when the sale deed was registered, he submitted that even according to the prosecution case, there was no demand made on 12th July 2004 at the time of the registration of the sale deed. He submitted that because of this material defect in the charge and omission of frame a proper charge regarding demand allegedly made on 6th August 2004 and 13th August 2004, grave prejudice has been caused to the appellant who could not defend himself properly. The learned senior counsel for the appellant submitted that in any event the complainant had not supported the prosecution and the shadow witness within bracket PW3 did not depose that in his presence there was any demand of the sum of rupees 500 by the appellant for returning the sale deed to the complainant. He urged that the offence punishable under section 7 was not made out without proof of demand. He urged that as no offence was made out under section 7, even the offence under clause within bracket D of subsection within bracket 1 of section 13 was not established. Dr. Joseph Aristotle, the learned counsel representing the state government, submitted that in view of section 464 of the Code of Criminal Procedure 1973 within bracket for short CRPC, no defect or omission in the framing of charge is fatal to the prosecution case unless any prejudice caused due to the said omission or failure of justice is established by the accused. He submitted that in this case prejudice has not been shown. He relied on this court's decisions in the case of Mohan Singh versus State of Bihar and Union of India versus ex-GNR Ajit Singh. The learned counsel lastly relied upon a decision of the Constitution bench in the case of Neeraj Datto versus State within bracket Government of NCT of Delhi for submitting that. Stop. Thank you. Jai Hind. Jai Mera Bharat.